Assalamualaikum and hi, my name is Syakirah binti AHMED and my matrix number is A20A1785. We are from group 9. The topic for our article review is application of ta'wid and gharamah in Islamic banking in Malaysia. Ta'wid and gharamah are two elements introduced in the context of Bank Negara Malaysia Guidelines on Institutional Late Payment Charge. Ta'wid refers to the amount that Islamic banking institutions may be compensated for actual losses sustained as a result of default. Gharamah is a penalty assessed to borrowers in addition to ta'wid. The Sharia resolutions in Islamic finance explain the basis of the permissibility ruling for ta'wid and gharamah, which is that a delay in payment by the customer will cause harm to the Islamic financial institution as the financier who will incur actual loss in the form of additional expenditures such as the cost of issuing notice and letters, legal fees and other related costs.
Hi, my name is NURIN binti MOHAMAD PENDI and my matric number is A20A1830. Okay, the issue of the article is to find out the position of late payment charge in Malaysian Islamic banking. One of the issue under the sphere of criticism is regarding financial penalty or late payment charge, which is said to be tantamount to riba. This late payment charge is one of the measures proposed by some Muslim jurists other than imprisonment. To deal with the problem of delinquent debtors in today's Islamic banking context, this financial penalty is recognized as late payment charge. The implementation of late payment charge in Islamic financial institution in Malaysia in the context of Bank Negara Malaysia Guideline on late payment charge for Islamic banking institution comprise two elements, which is ta'wid and gharamah. This happened because of negligent and non-negligent factors. Is it mentioned in the Bank Negara Guideline that Islamic banks are to ensure that the late payment charge are imposed only on negligent customers. A default by definition from BNM arises from negligence when it occurs, even though there are no reasonable mitigating circumstances, which includes cash flow problems, abandoned project, unemployment, loss of property because of natural disaster, as well as customer which could merit that will forbid the customer from making payments. Islamic banks are also expected to act judicially and have clear procedures to ensure that defaulters with genuine financial difficulties are exempted from late payment charge.
Assalamualaikum. My name is SYAZWANI binti SUHALIM. My matric number is A20A1662. I would like to present about the article contains new finding or significant information to the field of Islamic finance and banking system. First one, gharamah permissibility controversy persists. Although SAC has decided that Islamic banks in Malaysia may use both ta'wid and gharamah, and BNN has published recommendation for implementation, it appears that only ta'wid is generally used. Most Islamic banks prefer not to implement gharamah due to the fundamental character of riba, barriers in setting up separate charity accounts, transparency requirement, and restriction linked with it. This may have contributed to Malaysian and Middle Eastern academics an unanimous agreement of the permissibility of ta'wid, but it did not eliminate differences of opinion on the permissibility of imposing gharamah. Number 2, ta'wid, actual reward or opportunity cost. Using ta'wid as an amount that may be compensated to the Islamic banking institution based on actual loss incurred due to default, as defined in the BNM guideline on late payment charge for Islamic banking institution. This paper considers it anomalous if a late payment charge is imposed in cases where no judgment is involved. This is because, unless there is a judgment, the actual loss has not yet been assessed, just the potential cost. This is because Bank Risk Management Department and mitigation mechanisms are not developed in the case of late payment but already exist as part of banking operation. The establishment of a risk mitigation or recovery department, as well as the action taken via phone call or letter to remind customer to make payment, are all part of the bank's operational costs from day one and are easily priced in the financing facility provided to the customer alongside other prices components. This implies that it is the bank's responsibility, usually through the personnel of the risk department or the collection department, to notify clients when their payments are due. Only a court may determine whether the customer was irresponsible and whether actual direct or indirect costs were spent in the default case. As a result, the statement in the Sharia Advisory Council resolution that Islamic financial institutions will suffer actual loss in terms of incurring additional expenditure such as cost for issue notice and letters, legal fees, and other related costs. Is incorrect because there is no additional cost. In other words, both takwid and gharamah do not cover any related costs and instead function as a psychological deterrence approach to encourage consumers to pay on time. Next, the implication of the article towards society, policy, or practical. According to the Maqasid, it is appropriate for the bank to regard takwid as bank income because the bank incurs undue loss because of the customer default or delay. The only requirement is that the bank receive no further profit from the takwid imposed other than the real loss from the failure or otherwise. It amounts to riba al-jahiliyah, which is bank at its core. The notion of justice is completely functioning in this case, while the effective cause illah for the prohibition of riba, which is increment does occur in this situation where the debtor must pay more than the principal amount as a penalty for its own misdeed. The creditor does not gain any increment because the amount of takwid imposed upon the defaulting debtor is only enough to compensate the creditor's actual loss. Next, denying an Islamic bank the right to recognize takwid as bank income will create undue harm to the institution's reputation. Some people may believe that some Islamic muamalat norms are unfit for the assistance of an contemporary financial organization because they are too mild and hence prone to misuse and manipulation. The limitation on recognizing takwid as revenue will most certainly jeopardize the institution's survival and sustainability as entities create to provide funding to the deficit sector. If this occurs, the deficit sector will progressively be rendered helpless. Cannot be said about gharamah or the punishment, as it is more than the real loss. The bank cannot get any gain from it, whether financial or non-financial. The proceeds from gharamah must be directed to a third party with no connection to the bank. In Malaysia, it is required that the proceeds from gharamah go to charitable organizations. This exercise demonstrates not only the role of an Islamic bank as a financial intermediary institution, but also its role in protecting the interests and benefit of all parties involved in market transactions, promoting social harmony, ethical norms, and social commitment that are unquestionably consistent with the doctrine of Maqasid Sharia. That's all for me. Thank you.
Okay, next the current issue related to the article. First, an alternative of usury. This claim examines claims that the execution of this takwid is equal to usury. This is due to the fact that usury will only occur between money or usury items. This differs from the imposition of takwid in that it solely entails the exchange of money for items of various types and qualities. Consequently, it is evident that the imposition of takwid is an alternative to the prohibition on usury, but it is nonetheless one of the measures taken to prevent greater harm. Second, harm must be eliminated. As a type of early reminder to maintain the balance between debtors and creditors, the method of applying takwid is appropriate with a variety of conditions. In general, the maslahah lends significance to the pursuit of advantages and rejection of disadvantages. In addition, as the general maslahah should take precedence over the specific maslahah, the harm to the bank in this situation results from a failure to receive proper repayment of the loan within the specified time frames. Third, gharamah cannot be taken into account as an income. Gharamah revenues cannot be used by Islamic banks and must be deposited into a separate gharamah account from a takwid to ensure appropriate accounting management and oversight of the accounts. In addition, the SAC of Bank Negara Malaysia has taken a position mandating the Sharia Committee of Islamic Banks to select whether charitable organizations or institutions, including Islamic Treasury, are eligible to receive gharamah.
In conclusion, the article suggests that reducing the credit risk faced by Islamic financial institutions was the main factor for the implementation of late payment charge in Malaysia. Accordingly, it is recommended that Islamic banks need to think out of the box and take another approach in dealing with the situation. In line with this, it is important for Islamic banks to formulate strategies and guidelines toward practical application of verse 280 of Chapter 2 of the Holy Quran. This is to ensure that, in case when a customer payment default is the result of poverty, the client must be provided a respite until he is able to make a payment. This should be accomplished by upholding the Islamic bank's obligation to treat depositor with care while maximizing profit. Therefore, the author believed that method must be developed to stop the current practice of demanding tawid and gharamah, which seem to merely cause suffering for the client without taking into account his circumstance as the Holy Quran instructs. Since the fundamental rule of Islamic banking is eliminating riba and the principal object of Sharia is to bring it to people, then anything that is doubtful about or may contribute to riba and hardship must be eliminated and avoided in any circumstance. The objective of Islamic banking will be deferred, and the prefix Islamic attached to banking will lose its essence. There is need for Islamic banks to unanimously take action and deviate from the current practice, which is customer incentive, and find alternative way that consider the Quranic prescription with respect to customer to handle the matter. This will perceive and enhance the unique Islamic identity of the Islamic bank. That's all from our group. Thank you.